other aspect of this, Willis, which has to be given a lot of weight is, Willis, apart from what we just talked about, the trust vote, people tend to forget that in almost every assembly, there is a very interesting rule. You cannot bring repetitive no confidence motions also.
6 months.
Your Lordship knows 6 months. So I bring a no confidence against you, I lose it, I can't come after next week again, say I have no confidence against you. So, the next facet of this is the processes within the Parliament and Assembly have to be allowed to work themselves out first before external intervention. And one of the important processes is to notify a confidence or a lack of confidence. If your Lordship is so careful about not even allowing repetitive bites at the apple to destabilize a government, your Lordship will allow an external incursion without even a single no confidence motion. I'm not repeating, I'm giving Lordship in addition the larger context. Not even an attempt, because as they say, the proof of the pudding is in the eating. If you have the confidence, move the no confidence. It's your lack of confidence which makes you not move the no confidence. Because you know how the no confidence will be met. And may the best man win. If you have the guts and the courage, do it. Whatever will happen, will happen. That's the process of democracy on the floor. Incidentally, when I've done the maths, that chart, I mean, it is not that your Lordship will only ask them to show the material. We are having a preliminary objection that the governor doesn't come into it irrespective of the material, even if he has seen the material. I am now on concept, I am on juristic principle. There is no role of the governor till now, till whatever I have said, 2-1, etc., process, no confidence, no role for the governor. It's a second separate question on facts, what the governor saw, did not see, but he had no locus to see or not to see. So what's the point of going into down that path, fellows? The governor had no locus at that stage to see or not to see. Well, it would really amount to a very strange thing where the governor would, governors are now, obviously, if you read the debates of Mr. Ambedkar and now there's a vast difference. But governors are also creatures of political connection. The governor would say, I see a group of people here. Why are you bothered about moving a no confidence? Come to me, we will see something. There's no need for us. The assembly gets substituted. You will be circumventing and short-circuiting the entire process of a no confidence on the floor. Yes. Now, having given that answer, let me turn to my larger point on which I was really going to address your Lordships. And give your Lordship just bullet facets, and then I will give your Lordship the material underlying it, the juristic principles as to why your Lordships should deal with the matter here. Now, I understand that it is easier not to deal with it here. It is also equally possible not to deal with it here. There is a speaker. My Lord has heard enough facts. So, Lordship will take those facts as given. I will touch upon the facts here and there, but mostly no. In the event that the facts and the context suit your Lordship's discretion on this issue, should your Lordships in law juristically refer it or should you hear it is my respectful submission. There are four or five legal facets, then I'll give your Lordship the case law. The first is, that there were two, one negative and one positive order by this Honorable Supreme Court. That should be remembered. In whichever way, it is worded, the negative, I'll call it injunction, on 27/6/2022 was that by the expedient of extending time, the Speaker was effectively de facto could not pronounce on disqualification. It is nothing but an injunction in substance.
Till 12th.
Till 12th, correct. Then events took over, The events took over, but my Lord is right, till 12th. Therefore, let us look at it because the Lordship is always a court of substance. We can camouflage in so many forms. But your Lordship ultimately see this. In substance, it's an judicial injunctive interim relief way a speaker's future action under the 10th schedule. That is the correct way of putting it. It is well as a judicial interim intervention. It's a negative injunction. And the second was a positive injunction, if I may call it, or an order of 29th, allowing the trust vote to be held. So not injuncting the second day, injuncting the first day. So there is a negative judicial intervention followed by an affirmative judicial intervention. Well, as I am not making any value judgment. Your Lordship would have heard it next week, 2 weeks later. Who knows, but everything could have been reversed. I mean, I'm not saying that at all. I'm not saying right or wrong. But I'm saying one thing is clear, that the formation of a government, I'm making a neutral statement, I'm not allocating, is clearly the direct and inevitable result of the combination of these two orders. Your Lordship would have heard it next week and upheld it. So Lordship would be right. Your Lordship would have reversed it. Your Lordship would be wrong in the interim then. That's not the point. The point is, let us not see this case in the abstract, in an ivory tower, unrealistic approach. Let us see it in reality. We have to smell the constitutional coffee, if I may say so. The reality is this, that absent these two negative and positive orders, your Lordships cannot have this consequence of a change or a new government. This will have, correctly an effect on your Lordships needing to decide this year. Then, the second aspect, I'm only giving the legal bullets, I'll cite the case law later. The second legal aspect, the juristic principle, is the language of that order. Now, we all say it casually. Sometimes your Lordship is also made to say it casually. But these are terms of art. Your Lordship has used them for decades and centuries in law. And these common law terms of art have to be given effect to. Don't go to the page, just note your Lordship's order on 29th read like this, one line, quote unquote, subject to the final outcome of the instant writ petition as well as the writ petitions referred to above, unquote. That's your Lordship's order. This is my second facet. Subject to the final outcome of the instant writ petition as well as the writ petitions referred to above, which means the whole batch of writ petitions. By then, many petitions had come. What is the meaning of this frequently used phrase? And normally the phrase doesn't come up. Your Lordship has some very, forget this case for just 1 minute. Your Lordship has some very interesting examples in building law and construction. Well, the first time your Lordships ordered demolition, the first time, not now, of a 20-story structure was almost 15 years ago. Ironically, I think the second one was also from Lucknow. Both are Lucknow examples which came here. Your Lordship had passed only subject to. Construction will go on. Ultimately, your Lordships held against. Your Lordships ordered demolition. Demolition, in that sense, with people living and concrete and mortar in the building, is much more irreversible than merely a political thicket or a scrambled political egg created from 22 to now. Now I come to what subject to means. The object of this phrase subject to are two and threefold. One is that your Lordship's speaks in rem. Not just bilaterally between the parties, your Lordship speaks to the whole system, to the whole world. And second, your Lordship is giving a fair warning that everything which is happening after this is subject to, but on your risk and cost. And thirdly, your risk and cost means all consequences, equities, vested rights, all status quos you create each day after that is at your risk and cost. We are warning you. Don't blame us later. That's the meaning, Malas, of this, and I'll cite a case presently on that. Therefore, Malas, the moment, either your Lordship doesn't say it, the moment your Lordship says that, no one can come and plead equities, vested rights, events, scrambled egg, irreversibility, etc., etc. Because your Lordship takes into account this in advance. If your Lordship passes subject to today, it is different from passing in 2022 June. The fourth facet of law, which I will develop in a moment, is that third. I'm sorry. What is third? Third. This is Manus, now. It's called pointillism, Manus. Pointillism. It's not a bad technique, Manus. It makes it for specificity and a certain amount of clarity. It may not always be. It is liable for some intellectual property protection also, Manus. Correct.
More than anything, you will know when you are going.
Now, Manus, the third one is para 110 of Quixote, which your Lordship has seen right at the beginning of the Navam Rebia arguments, but Lordship may kindly be reminded of that. Just turn to 110 in Manus, the first compilation, PDF, page 74.
First judgment compilation.
Judgment compilation. Or basically, Malus, the very strong constitution bench injunction when the jurisprudence of 10th schedule was starting. Quixote is Malus virtually the first. I mean, there were some cases, virtually the first, certainly the first constitution bench and the most important 10th schedule judgment at that time. Malus. They started this jurisprudence with this Malus, great warning and mandate. PDF 134 or 74? 74. 74, the Kyoto starts at 134. At 134. Para 10. Para 110. The full thing is put here. Full thing is good. In view of the limited scope of judicial review, may I read it?
Yes.
In view of the limited scope of judicial review that is available on account of the finality clause in para 6. So, your Lordship gives basis for it, finality clause in para 6. And also having regard to the constitutional intendment and the status of the repository of the adjudicatory power, Speaker, Chairman, judicial review cannot be available, mark these words, cannot, Constitution bench is saying, cannot be available at a stage prior to the making of a decision by the Speaker, Chairman, and a quia timid action would not be permissible jurisdictionally, threshold, nor would interference be permissible at an interlocutory stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceedings, and such disqualification or suspension is likely to have grave, immediate, and irreversible repercussions and consequences. But I'll just pause here. It has some very startling consequences. If your Lordship reads this, it's a constitution bench. It makes only one exception. When I, the Speaker, by an interim order disqualify you, that has happened hardly ever. Well, this happened once or twice, but it is not really happening in the 10th schedule. Maybe that will be a new technique adopted in the future. Well, I don't know. But today, well, it's hardly any case. But
you are giving the idea.
No, but Quixote gave that idea. Quixote has given the idea already. But that's why I'm saying from 92 till now, it has not happened despite Quixote's idea. I mean, it may have happened one or two cases, but hardly ever happened. Yes, Kuldeep Bishnoi case, etc. But Malaz, in that exception apart, it is per se jurisdictionally bad. So therefore, Malaz, a perceived error of the Speaker's conduct will not justify your interlocutory application. That's important. Let us assume that the Speaker is wrong. Nobody is conceding that. Let us assume that the Speaker is grievously wrong. That will not justify circumventing of a constitution bench by saying Normally we will not interfere, but here, by a matter of degree, I opine that he is grievously wrong, therefore we will interfere. Well, let's take an example. Your Lordship has applied that example for decades. This is not something strange at all. Kyoto was, according to me, saying the obvious in a much more important category. Your Lordship has done it for lesser category. Well, as your Lordship finds genuine problems in an election process. When an election process starts, your Lordship finds genuine cases. My nomination rejected badly. I was stopped at the door by a guard. I couldn't enter. Somebody obstructed me. I couldn't file in time. This man is rejected on a comma, full stop, wrong ink. They are very compelling arguments. Your Lordship says, come after the election. In 99% cases, unless there's a special statute. Because you don't interdict an autonomous, self-contained scheme of a code there to let elections go on. Here, a much higher constitutional authority to allow unfettered proceeding further. There are many more examples the Lordship has. Therefore, the position which by a combination of the positive and the negative order inevitably led to the change of government possibly was also constitutionally wrong. Had your Lordship had occasion to discuss it in the 2 weeks following that, your Lordship would have rectified it. Today, it cannot be a bar merely because of passage of time, because this is on the face of it contrary to your Lordship's constitution bench. And a error of the speaker was irrelevant. In fact, he hardly had opportunity to commit many errors except perhaps as a 2-day notice that would have been decided. I've cited, Lordship members, 2 cases I cited in the Navam Revia, where 3-day notices were sufficient. Yedurappa and, Yedurappa was the other way, Nayak and Balasa, Patil. Srimant Patil. Three judges, 3 days, sufficient. When the rule said 7 days, I hope my Lord remembers that. In Navam Revia, I cited those cases to your Lordship. Rule said 7 days, 3 days notice. 2-judge bench in Ravi Nayak said okay. 2-judge bench in Yedurappa doubted it. 3-judge bench subsequently affirmed the Nayak principle, despite noting and citing Yedurappa. Then, the 4th facet is that the more important and the more general principle, but equally important, that your Lordships respects co-equal organs. There's a whole other line of cases. When I come to my notes, I've cited some of them, where your Lordships is very careful, because your Lordship now doesn't think of an individual speaker, but of the institution, where your Lordship doesn't enter into co-equal branches unless there are compelling reasons. So respect between and mutual balance between judicial and legislative organs is the other legal principle which has to be kept in mind, and all this goes towards making the non-interference principle at that interlocutory stage. Then the other facet which your Lordship in case law has used is, there may be a rarest of rare exceptional situation where your Lordship passes interim orders, not in this case, no case, I'm saying generally, now I'm not going to tension you, to maintain a status quo. But your Lordship is very, very sensitive and cautious and careful to create a new status quo by an interim order. Maintaining a status quo and leading to the creation of a new status quo are two different principles of law looked at and dealt with differently by case law. Here clearly a new status quo was created. The 5th principle is actus curiae. Obviously, actus curiae arise in the event that your Lordship finds that I am partially right or fully right, not otherwise. But if your Lordship finds, then your Lordship reverses the most intertwined situations, because the Lordship never allows the act of court to do any harm. Actus curiae nemine gravibit. The sixth facet is, Malas, that if there is a right made out, I'm sorry, my apologies.
No, 6.
Seven.
Next. My, actually, well, I dictated these later on, so my numbering is also in A, B, C, D, E, F, G, because the main submissions are below in 1, 2, 3, so I don't have those numbers. But Malas, your Lordship is right. I'll say next, your Lordship will have your own numbering.
Yes.
Well, is what your Lordship, I'm sorry, this is not that we are using Latin. Your Lordship has warned us in recent judgments against using Latin, but these are basic principles. The other one, Wallace, is ubi ius, ibi remedium. If your Lordship finds that I have a right, in this case a constitutional right, made out by all this which we have been arguing, then Wallace, at the end of that right to say that I am remediless, the remedy which is effective and real is only a reversal of the status quo ante, as would stand immediately prior to the consequence of those two orders in June. The consequence being the change of status quo on 4th July? 4th June. 30th June is the swearing. 30th June is the swearing. I'm sorry, not 4th July, 30th June. So it must be a status quo ante. In the event that your Lordship applies the principle, obviously ibi remedium doesn't arise unless there is ibi use. If I don't have malus the use, I don't have the remedium. But on the assumption that I have, then malus, your Lordship will not be told it's a fait accompli.
So what would then be the consequence, Dr. Singhvi? What does the court then, logically, what would be the directions of the court?
Well, logically, the direction is that that particular act of swearing in is wrong, and your Lordship will have the whole thing done again. Your Lordship could then, to give your Lordship, your Lordship give a substantive answer.
Yes. What will be the substantive directions then?
Yeah.
Just to...
Now, I am giving your Lordship a substantive direction. Of course, I will develop the law which is yet to come. In the event that that is correct, and that is the majesty of the law, that is what your Lordship means when your Lordship demolishes 25-floor buildings. And the message goes that your Lordship is ultimately establishing the supremacy of the law. Supremacy of law is by no other means except by result, by actual de facto on the ground result. The rest remains paper and words. It would be a reversal of that oath. I'm being very formal and constitutionally proper. A direction.
Oath is on 3rd.
No, that's I thought 3rd is 30th. I also thought 3rd. That's why I said 3rd. Apparently, it's on 30th.
Because on 29th...
that's right. That's correct. That's correct.
Of course, that's correct. 29th evening.
That's correct. Doesn't matter, 3rd or 30th, but reversal of the day before that. Second, for the purity of the process, your Lordship will, there is still a Deputy Speaker, should decide what he would have decided but for Lordship's injunction. Because your Lordship is now counting the status quo ante on the but for test. But for these two orders, what would have happened? Obviously, only this would have happened. There would have been no swearing in and there would be a decision. Well, it sounds sometimes difficult, but imagine. Yes.
So far is
kindly note.
Dr. Singhvi.
Yes.
When you are on the interim injunction, not granting interim injunction on 29th and to see that the status quo ante is maintained, it was only with respect to the floor test on 30th.
And he resigned. That's what, and Lordship is asking. No,
1 minute. You can read the... on 30th, on 29th, he resigned. The order dated 29th, not granting injunction was very clear. That the floor test on so-and-so would be subject to the, floor test on 30th would be subject to the ultimate outcome. Correct? Now, in that case, correct, raise the question of status quo ante.
Yes,
correct.
I'm
on
very grateful.
29 on the basis of the 29th injunction or not granting injunction.
I'm very grateful for a query. Your Lordship was put it in a different way earlier. I must answer it again. It's very opportune at this moment. Mills, there are two answers. One answer I gave 3 minutes ago, Mills. Your Lordship's court is a court of substance. Always, not of form. Let me develop it. I'm answering only my Lord's query. Paramount is substance, the heart of the matter. It is true that on that day, on 29, nobody would know what would politically happen on 30th. And it is true that the technical word used is trust vote. But Mills, what was allowed to go on was a test on the floor, which is inevitable if 39 vote against. The one and only foregone conclusion, instead of suffering the humiliation of a vote, is to give up in advance. I mean, we are in a real world. There is no arithmetic, no science, no physics, which can change the result on 30th. If these people who comprise this, so the floor, I argued the matter on 29th and the earlier dates. One of the main arguments was that the moment your Lordship permits these people to vote, we were seeking an injunction. Where, how can there be a trust vote with a tainted, how can you have a swimming pool with some part of it tainted with poison?
No, therefore your submission seems to be
that was not accepted.
That not granting the injunction,
yes,
correct, would in fact had facilitated those 39.
No, it was an additional argument, Balas. I'm very grateful. One argument was that this trust vote is, Balas, completely unreal and futile because you have not excluded the tainted fruit.
On the other hand,
the other argument was, Balas, that if your Lordship has stayed that, stay this also. That was a more important argument.
The flip side would have been that
stay both.
Dr. Singhvi, if you had faced the trust vote,
yes,
on the 30th,
yes,
these are open. This is an open vote.
Yes, yes.
Right, because you have to, because that's the whole principle of the whip. If you had faced the trust vote and lost, then it would have been clear as to whether these 39 people made a difference, how they voted, and whether that made a difference to the ultimate trust vote.
So we did not do it. It's a given fact. I can't change it.
Right.
Right, Balas?
Right.
I'm answering. Balas, let me answer this also.
And the voting pattern would then determine as to whether these 39 who are otherwise facing disqualification motions,
yes,
whether they affected the trust vote or otherwise.
But I appreciate it. No.
If you had lost the trust vote only because of these 39,
yeah,
then you absolutely a plausible point that, look, these disqualifications, if they get disqualified, then I win the trust vote. Isn't it?
Malas, let me. So the first part is the conceptual.
I mean, the area is not free from doubt. The reason we are putting it to you is
I,
because there is a constitutional question in our mind. That's the.
I hear your Lordship loud and clear.
Yes.
Let me, because certain given facts for us, we can't argue about. The fact of the matter is, nothing happened on 30th. The man did not, Malas, go to the trust vote. No doubt about it. Now, Malas, the first conceptual answer is, we are now, Malas, on what I have been saying and Mr. Sibal has been saying earlier were legal errors. Whether they were or not, the Lordship will decide on Malas 22nd, 23rd orders. But the argument regarding 29th order was that either you should not have stayed that, but if you have stayed that, stay both. You can't stay that and allow this vote to go on.
Right.
That's the first point to be remembered.
If you have stayed the disqualification, then stay the trust vote also.
It's very unfair and uneven and non-level. Well, if your Lordship is hearing the matter next week, I believe it was on a Monday next, it was listed. Then both could have been held afterwards. The Lordship, as well as in the Karnataka late night matter we did, your Lordship said, not today, next morning, it will happen at so-and-so time. The reverse is also true. Don't have it there, have it after 4 days.
So your argument to therefore restate your argument, what you are really arguing is this, that once you stayed effectively the speaker from deciding the disqualification petition, then you should have stayed the trust vote also, because one was linked to the other at the least.
The word linked, inextricably intertwined, absolutely. And that is the answer, the first answer on the conceptual query raised by my Lord Justice Shah.
No doubt
It is
about
true. Technically, one is a trust vote, one is a floor test, one is nobody comes.
But you're right. I mean, because
Substance is
at the
what?
trust vote, those people were going to vote.
So that's the first.
That-
Now, second, no, I will go further. Since your Lordship has put a different question.
But still, Dr. Singhvi, the problem's still in your path. I mean, the problem still arises.
It would have been
that,
shown on that.
the
Definitely.
consequence of these 39 would have really.
No. So let me show.
only at the trust
Therefore,
vote.
Malus, no, therefore. Now that will not affect this question. Let me be conceptually clever. My Lord's query is right, but Malus, that will not affect the question I'm arguing now. That will affect, as and when your Lordship takes up the disqualification and says that we find that no disqualification occurs because we don't have sufficient proof to disqualify. That's all that will mean, Maharaj. It will only mean that I have insufficient evidence. And I'll tell Lordship why your Lordship